We're turning our attention to an amendment to draft number 1.1 to H44. And Legislative Counsel, the esteemed attorney, is going to review the changes to H44. Over to you, Ben.
Thank you very much, Mr. Chair. One moment as I log on to the Zoom. For the record, my name is Ben Novogrodsky from Legislative Counsel. I appreciate being called esteemed. However, I don't feel it's yet been earned. I'll take it. So with that in mind, I will pull up and share my screen, a copy of the amendment to H44. So I have to preface this that this has not been edited, so please be mindful of any errors you may come across. It will be edited by the time you vote, if you vote. So with that, I have highlighted the changes from the as introduced portion to this portion. And as a moment, like maybe a teaching point for some of our newer members. So this is what we would call a strike all amendment. So what a strike all amendment, there are various forms of amendments that you can do to the introduced versions of bills. You can have a strike all, which you'll see here, which literally is striking all the text from the initial as introduced version and replacing it with whatever you see before you. There can also be an instance or multiple instances of amendments, which will sort of can look a little odd, but it's really without context. You're saying on this line, this word, we're going to either strike it or add or whatever. So it's harder to kind of understand in the broader context. So this committee typically sees strike all amendments. So that is probably what is going to be the general amendment of choice, so to speak. But I just wanted to point that out at the initial point of this, that this is what a strike all amendment looks like. But
we can, and after we go through this, we can also go back to what's it called? The
instance of amendment. Yeah,
we can, if we decide that that's what we want to take to the floor, but it's definitely easier for us in here to see it this way as well.
Okay, of course, your prerogative. So with that in mind, I'll go down to the first change, which is on page 2, line 5, and the addition of or adjudication. So it would now read that the Family Division of the Superior Court shall forward a record of any conviction or adjudication. And the reason why is because of the changes concerning youthful offenders, because their dispositions rather aren't considered criminal convictions unless they have somehow kicked to criminal court. So in the family court, it's an adjudication, and that's why this is implemented here. Going down, you'll see just affixed to the cross reference on page 3, line 15, just to be more accurate in that. And then scrolling farther down, you'll see the striking of what would have been new subdivision B2 in 1201, which was that refusal to comply with a search warrant. And then at the suggestion of prosecutor, I'm going to butcher your last name. I'm so sorry. Oh, it's just Wigmans. Okay, so it's as I thought. That at his suggestion, some new language, which may be further modified by forthcoming testimony, will replace this farther on down. So that replacement is seen as new subsection J in 1201, and which we're to read, and this is on page 6 at the beginning on line 1, that a person suspected of violating this section shall not hinder the collection of an evidentiary blood sample when a warrant for that person's blood is issued pursuant to subdivision 1202 F1 of this title, which is the provision that talks about implied consent for blood samples and then also for warrants that are necessary. And the subsection shall not be construed to as impairing that person's right to challenge the validity of the search warrant in subsequent legal proceedings. So it's just an obligation to not hinder the execution of a search warrant, essentially. But if you want to challenge that search warrant, it is still available to you. Just in those legal proceedings, as they would normally go in due course. Any questions on the new addition of the obligation to not hinder search warrant? Feel like there's some thinking.
Can you just say no?
I mean, you can.
Would that be hindering?
Potentially, yeah.
And so by
But if
making,
it's a lawfully issued search warrant, typically while it's a charge on law enforcement to abide by the terms of the search warrant based off of what they stated to the judge as probable cause to issue it, it also provides a legal authority that you have to comply to it. It would be different if it was a warrantless request.
Yeah.
And there's case law on the ability to do that, but I believe sort of the under, then this implicates Article 11 of the Vermont Constitution, which is our equivalent of the Fourth Amendment right against search and seizure. That essentially the choice that is being provided here is that we're not criminalizing. So you have the choice of either consent to the request, but then there's, refusal to do so may lead to other consequences, which is what we're outlining here.
so, yeah, so we want basically there to be like a refusal charge for not
And
getting.
that'll be in 1202.
But then, is this necessary? Like, you have to comply with the warrant if they've legally gotten it.
Well, so what we discussed in prior testimony is that right now that situation is occurring, but what the recourse for the prosecutor is charging them
With
with
that's
with
right.
an
Thank
offense
you.
that has more serious consequences associated with it, which is like obstruction of justice, which is, I think it's a 5-year felony
Yeah,
and doesn't have the sort of rehabilitative aspects to adjudications that are associated with these DUI laws.
yeah.
So that's sort of the policy choice, I suppose, for the committee is, do you want to go with this route or what's been going on or anything else that one may think of?
Yeah. Sorry to interrupt.
No, that's a good question.
No, it's good, thanks.
Okay, moving on to the next change. And so you'll see here that we're striking from refusal to comply with the search warrant to, and so this is, again, just in the context that if the person refuses to take an evidentiary test, that refusal may be offered as evidence against the person at trial, whether or not a search warrant was sought. And you could be charged with a crime of criminal refusal now with the addition of that hindrance. So you're not criminalizing, you're not giving them sort of a Sophie's choice in that moment, but it's sort of this consent that, okay, you either do this or there's this possible consequence of the criminal refusal. So that's what it would, so subdivision C is establishing the basis to bring that criminal refusal for the hindrance of the collection of the blood sample.
So is there any problem with the fact that in line 6 and 7, it talks about whether or not a search warrant is sought? Is it not a problem because in line 17, we actually say when a warrant for that person's blood was issued? Is that an inconsistency there, or is that taken care of by the fact that line 17 specifically ties it to a warrant being sought? That makes sense.
It does make sense, and I don't have an answer at the ready right now. Give me a little bit to think.
Yeah, because those kind of are conflict, aren't they?
But I would also say, as I think about this, that there are warrant requirements, or not requirements, but procedures for the refusal of a saliva test, and also not for the evidentiary breath test, but you do have another, I guess, reference to this in subsection B. Person may be charged with criminal refusal if in a crash involving SBI or death, which the court may issue a search warrant and order that person to submit to a blood test, the results of which may be offered into evidence against the person. So maybe we kind of mirror the language a little bit to be in line with that as well.
I'm
Um,
confused by that, but I can also ask the other witnesses also to weigh in on that.
Yeah.
That they've
gives me
been
more time to think too.
well, and they've been practicing with this a lot.
So we'll hold off on getting those answers. And then the next change to this is all the way towards the bottom, which is the establishment of a task force to essentially streamline the processing process for implied or impaired driving investigations. So this would be on page 21, starting on line 13. So it creates a task force called the Impaired Driving Processing Task Force to study the concept of implied consent during impaired driving investigations with the objective to recommend approaches that minimize the duration for which impaired driving suspects are held during investigations and to streamline the processing and paperwork associated with such investigations. The task force is composed of the Defender General or designee, Commissioner of Public Safety or designee, the Commissioner of Motor Vehicles or designee, the Executive Director of the Department of State's Attorneys and Sheriffs or designee, and a representative from the Vermont Police Association. The powers and duties of the task force are to study the impaired driving investigations in Vermont, including specific issues concerning the constitutional and statutory requirements of implied consent, how constitutional and statutory requirements related to implied consents affect the duration for which suspected impaired drivers are held by law enforcement, methods to minimize statutory requirements related to implied consent that pass constitutional muster, and any other relevant issues in accordance with the overall charge of the committee or of the task force. Assistance is provided by the Department of Public Safety, and then the task force is charged with submitting a report by November 15th of 2025 in the form of proposed legislation, which would go to the House and Senate committees on judiciary with any recommendations for legislative action. Subsection F goes into the meetings. Commissioner of Public Safety calls the first meeting on or before August 1st. Task force selects the chair, no more than 6 meetings. A majority of membership constitutes a quorum, and that the task force will cease to exist on February 1st of 2026, which provides the committees of jurisdiction some opportunities to question the task force in the beginning part of the next session before they've been disbanded. And then compensation, basically, if you're not otherwise compensated by your job, you're entitled to compensation and reimbursement for of expenses.
Can you go back to the list again?
Yes. At the top there, line 1 through 6.
Yeah, I don't think any of those would get compensation. Ken?
Is it this, are we basically already doing this? I mean, isn't this task force really already being monitored in so many different ways? I mean, we're just creating another process.
Well, you are creating another process.
Maybe that's not, maybe.
But the task force doesn't exist already. What it would do, though, is that there was some concerns raised at the last hearing about, you know, the paperwork that's associated with this, and that might be informed by what you have to say during an investigatory stop for a DUI, which then affects how long you have to hold someone. So this is analyzing what that encounter really needs to look like under the Constitution, and then whether or not the statutes that we have on the books can somehow be minimized and still meet constitutional muster to help minimize the duration of law enforcement encounters, and then any processing and paperwork associated with that for law enforcement.
So I understand that, and maybe this isn't a question for you, but aren't we already monitoring all this that this task force is being set up to do?
Not that I'm aware of, but I would defer to any colleagues that may have other information.
I mean, we have to be following some guidelines that's set up like this.
Well, they are, but there's a question of how well they are working. And it takes from what I understand, a very long time to process these individuals. Is there a way that can be streamlined?
So and in this section of statutes or portion of statutes, there are requirements. So implied consent is outlined and what it looks like. And the general concept of implied consent is that by having the privilege to drive and use the roads in Vermont, it's sort of a bargain that said, okay, you've now given standing consent for sort of these limited intrusions on your person, right? And then, but in addition to that, there's a list of things that need to be discussed at roadside between the law enforcement officer and the suspect. So I think the question kind of centers on, are those statutory requirements of what that kind of outline that interaction, right? You have to inform them of their rights, what implied consent is, what the consequences are, things like that. Is there a way to minimize those requirements and still retain the constitutionality of the procedure? Which would then theoretically, if you could do that, theoretically minimize the time and paperwork associated with those questions and the paperwork that you need to submit based on the individual's answers. Does that make sense?
No. No, not one bit, because it seems like to me like we're just adding on more and more of a burden, taking more of that officer's time at the stop when we've already got it covered. What am I meant?
So this is to precisely do the opposite. Tom, did you want to weigh in?
Sure. I suggested this because it's such a large cumbersome process.
You suggested it? Then I'll shut up.
Okay.
So when it's coming from me.
You know, Ben, it would have been a lot easier if you would have just said that Oliver was doing this and I wouldn't even.
We wanted to see you keep on going for a while first.
You wanted to bury me. Okay, I can handle it.
Me too.
Payback, buddy. Payback.
All right, so
I apologize for the confusion.
there was no 10 out of 11 people were that confused. Anyway.
Wow.
I didn't say who was, I was meant myself. You thought I was talking about.
Get on Kenny Day today, isn't it?
But it was implied.
Message
Any other questions for Ben?
One procedural question. So these temporary task force are written into statute?
This is the session law.
Yeah, session law. It will be.
Okay.
And typically with session law, it's things that are time limited or.
Yeah.
Yeah.
Okay.
So this is
Yeah.
fitting for.
That makes
session
sense.
law. Yeah.
Definitely. Cool.
Anything else? Okay, for Ben. All right, so let's hear from Marshall next. Thank you, Ben.
My pleasure.
I'm sure you might have helped me out a little bit, by the way.
Nice stuff. I'm sorry, I didn't.
You enjoyed it too? You enjoyed the show?
I don't know, it's from Oliver, I would have told you if I knew. I wouldn't let you down there if I knew.
At least I got one friend in here anyway.
If that's things of fun. Law enforcement? Yeah, thank you. Alcohol from the Office of Defender General. Our testimony will be pretty brief. We are broadly supportive of the changes that have been made to this. I can address, there was a question during the walkthrough about page 9. And essentially whether or not I think the way that I understood the question was that the provision in C that provides that you can be prosecuted for criminal refusal if you hinder the collection of an evidentiary blood sample with a warrant. And whether that conflicts with what it says earlier in 6, where it talks about that if a person refuses to take an evidentiary test, whether or not a search warrant is sought, whether there's a conflict there. I don't think that's a conflict. I think that subsection 6 does 2 things, and it maybe this should be divided into 2 different subsections, but the way it's written now, it does 2 things. One is that it provides that evidence of refusal can be used in court. And then second, it says, under the following circumstances, refusal can be criminally prosecuted. And those are 2 just different questions. We use a different standard for what can be admitted in court and what can be criminally prosecuted. So from my perspective, there's no conflict there. There's no need to reconcile anything. Those work fine.
Yeah, good.
The only changes that we would propose to what's remaining in this bill are pretty minor technical things. The first one is on page 20. And it would be a change to lines 11 and 12. And the current proposed version reads, notwithstanding subsection 1, an order of delinquency or establishing youthful offender status should be reported, et cetera, et cetera. The problem with that language is that establishing youthful offender status is not the same as an adjudication. You can get youthful offender status and then be found not guilty because you didn't do whatever it was you were accused of. So what I would propose changing that to is crossing out the words order of delinquency or establishing youthful offender status and replace that with order of adjudication pursuant to section 5281 sub D of this title. And that's because 5281 sub D is the section on orders of adjudication that applies both to delinquency and to youthful offender proceedings. So it captures both in one. So that would be the first proposal.
Could you say that language again? I want to make sure I had that.
Sure. That an order of delinquency or establishing youthful offender status is replaced with an order of adjudication pursuant to section 5281 sub D of this title.
Pursuant, one more time. Adjudication pursuant.
To section 5281 sub D of this title.
Okay, thank you.
The other change that I would make is on the next page. And this is right around lines 8 and 9. And this is a change, there's two changes I would make here for two different reasons. So I'll do them one at a time. The first one is just for the sake of simplicity. This is going to be something that's used by juvenile lawyers. Juvenile lawyers are typically carrying around this book with them. They're not typically carrying around a copy of Title 23. And so what I would do is I would take the language that's in 23-1709 that says what types of adjudications have to be sent to DMV. And I would put that language right in this section. And so the language I would add is where it says and shall send a record, I would delete and shall, and I would start that as a new sentence with if the delinquent act relates to a violation of state or local law regulating motor vehicle traffic control other than a parking violation, which is a direct quote out of 1709. I just put that in there so that everybody knows what offenses need to be forwarded to the DMV and what don't without having to go find a copy of Title 23. I think that just makes life a lot easier for juvenile practitioners. The final change, and I think this is also a minor and technical change, is in that same section, it says send a record of such findings.
So what about the 4 VSA 33B? Is that also included what you just said?
Yes.
Okay, all right, that language is from both.
It's different language in 33B, but it's less specific in 33B. So I think 1709 is the more specific language, and so that's what I used.
Okay,
But either one is fine. I mean, just anything so that people know without having to cross it, because I mean, nobody carries the Title IV with them. I mean, Title III maybe, but
okay.
nobody carries the Title IV. Yeah, it might be good to actually bring the Title IV language in as well. But the other change that I would make in this same section is where it says send a record of such findings. I would change that to send a record of the adjudication. And the reason for that is when you're talking about criminal court, when they say a record of, a conviction, that's either going to be a record of a plea, or it's going to be a record of a guilty conviction, probably by a jury. In juvenile court, we have bench trials. And so the record of such findings might be a lengthy decision by a judge that's highly confidential and is chock full of information that DMV doesn't need. Like what DMV needs to know is about the conviction or the adjudication. And so providing them with a record of the adjudication is really what we want to do. Providing them with the court decision deciding that somebody was guilty, I'm not sure is what they're actually after. And it would put a burden on them because then they become custodians of a lot of confidential information that they don't really need. So I would change it to record of the adjudication. And I think that just spares us from having to share lengthy juvenile court documents too far. And other than that, I have.
And is that, Marshall, is that a known thing? A record of adjudication is a thing already?
Yes, we have records of adjudication. I mean, I think you could point to several things in a court record and say any number of them are a record of the adjudication. You can get a certified copy of the docketing summary, and that will contain a record of the adjudication. You could get, sometimes judges will write a decision with findings and then a separate order that just simply says that the child has been adjudicated. That could be the record of the adjudication. There's many different things that could be the record of the adjudication.
Should we be more specific then?
I don't see a need to. I mean, I think the fact of the adjudication is what DMV needs to know, and this tells the court to send that fact to DMV, and how they do that, I think is probably best left up to the court and DMV.
So well, I just want to make sure that, so it's safe to assume then that it would be understood based on what we're writing, what we're saying here, that there would need to be that communication, and that it would be a uniform notice or, record that, you know what I'm saying? Like,
It doesn't say that here, but in practice, whenever we're sort of tasked with doing something, we develop a system around it. And that's what we do. It's not as if everything we do is guided by statute. Statute gives us sort of general principles of what our job is to do, and then we sort of
figure out how to do it.
figure out how to do it. But we come up with systems, and we do things consistently, because otherwise we'd be tearing our hair out
Right.
if we just made it up every time.
Yes, and I think we are constantly trying to find the line, which, come right up to the line of like providing enough information and clarity. Say, here's what we intend, and we're not trying to raise a bunch of questions for you all in the field to like wonder how are we supposed to do this.
And I think this provides enough clarity. This has been a longstanding issue, and we are all aware of this issue, and we are all aware of exactly what this portion of this bill is trying to solve, and we all want to solve it. So I don't think it's going to be a problem. I think this is something that everybody's wanted to solve for a while now, and we're all sort of pushing in the same direction. And I think the language in here is plenty adequate to give us that direction.
Okay, great, thank you.
So Ben,
Yeah, I mean, I agree with Attorney Paul that adjudication gets us there. Could be more specific, because technically an order in this context in youthful offender proceedings is a disposition order.
I don't agree with that, actually.
Well, if it's still in family court. But if it could also get kicked to criminal court if you're a youthful offender, and kind of use your youthful offender status. Adjudication covers, in my view, conviction and a delinquency, which.
To clarify a little bit, the disposition comes after the adjudication. So there's an adjudication in youthful offender court. And it can be hard to see that, because in the statute on youthful offender status, it's like one line in one subsection where you go from getting youthful offender status to then a reference to 5281, which is the statute on doing a merits hearing in juvenile court. And that's where you do the adjudication. And then it jumps right into the disposition process. But the disposition process really is separate. It's not what should be sent to DMV. The disposition order can be lengthy, and it goes into everything. So in a juvenile case, like in a criminal case, after every adjudication, there's a disposition, and the disposition goes not just into sort of what do we need to do to sentence this person like you would in a criminal case. And instead, it's a much broader look. It's sort of taking you're going to do mental health screenings, substance abuse screenings. What are all of the issues that this person is facing and what could be done to help address them? They're often 20, 30 pages long, and they have a lot to do with, mental health treatment, all kinds of details like that. So I don't think it's and also the other thing is those disposition orders often come out long after the adjudication. And if what we want is for DMV to be suspending licenses promptly after adjudication, what we want is the record of adjudication, not the record of disposition. And we want it to be sent promptly after adjudication. So that's why I would say that this is really an adjudication thing, not a disposition thing. And I do think the adjudication language is right because, especially with the cross reference to 5281 sub D, because that is that is the statute in the juvenile section, and it is cross-referenced in the youthful offender section, so it'll capture all of those adjudications. And as far as a youthful offender adjudication bouncing back into adult court, that would only happen after somebody has violated their youthful offender probation. So again, you're talking about if you were waiting for that to be the trigger to notify DMV, that might never happen at all. In fact, in most cases, the vast majority of cases, that never happens. So really, if what we're trying to do is notify DMV promptly of somebody being adjudicated of a motor vehicle offense other than a traffic ticket, I think the language of adjudication is the language to use, and I do think this captures
Good. So I'm going to ask, so Dennis and Judge Zoni, you both completely follow, because I want you to respond to that when it's your turn. Okay. In case you had any questions for clarification from Marshall, I'd like just, okay. All right. Anything else on that, Marshall?
it.
Any questions? All right. Dennis Wigmans, please join us. Thank you. And why don't you start with what we were just talking about? That's right.
Sure.
We just talked about.
Dennis Wigmans, Department of State's Attorneys and Sheriffs. So to address the delinquency versus youthful offender in 5281, my understanding is that 5281 under our juvenile delinquency statutes has actually been repealed. It only appears under in chapter 52A, which is youthful offender. And so my only concern with just calling it adjudication as in 5281, then someone will look at it and go, oh, gee, we're just talking about youthful offenders. We're back to square one on delinquencies. So I might add just adjudication, delinquent, and consistent with 5281D. Does that make sense?
I'm not sure. Say that again.
Okay. So I was just looking.
What was the language that you're proposing? I got
Right. So looking at Title 33, and I noticed that under the chapter for delinquency, which is 52, 5281's been repealed. It was added in Chapter 52A, which is for youthful offenders. And so the subsection D, if the family division accepts the case for youthful offender treatment, the case shall proceed to a confidential merits hearing or admission pursuant to sections 5227 and 5229 of this title. And so I'm not sure that it gets us there because you haven't had the merits yet. And so I think that we need to somehow figure out, I think that what Attorney Paul talked about is a real issue because it's still maybe not perfectly clear. I definitely agree that DMV does not need the entire package, if you will. I think really all they care about was, was the statute violated or not? So if there's a way to address this, I'm all ears.
Okay. All right. Yeah, Marsh, go ahead.
Because I'm noticing that I made the same mistake. I was looking at a 2024 law book, and 5281 has been repealed in the delinquency section, but we could remedy that by saying section 5281 or section 5229, because that was what replaced it for merits adjudication and delinquency.
29?
5229.
Okay. Oh, right, I was talking. Let me look at it if I can see.
So,
I think that actually, yeah, if you just say, merits adjudication under 5229 would cover both cases because, D refers offenders to that process. Would you agree? Yeah, so I think that that would actually cover it.
so an order of adjudication pursuant to 33 BSA 5229.
Yes, I think that should answer any questions.
So the next one that talks about on page 21.
There. Are we talking about the task force? Or,
Well, in 5229 merits and adjudication, Marshall had a.
oh, yeah, using that language, I think is perfectly acceptable, just basically throwing the 1709 definition in there. I too spent some time in juvenile court, and I very rarely had Title 23 with me. So usually I only had the packet that I think Marshall played a large role in drafting, because I was one of the juvenile defenders for a time in Addison County. The only other thing I wanted to look at was with regard to hindering, it is a term of art. It is defined by our court. And I think there's a particularly good definition of it in State v. Stone. And State v. Stone defines hinder, which has also been defined in State v. Oren, to slow down or to make more difficult someone's progress towards accomplishing an objective, to delay or impede or interfere with that person's progress. And so in impeding, which is where we borrow this language, if a person's duly authorized to issue, for example, the judge issuing the search warrant, and then the officer who's been duly authorized by the judge to go ahead and conduct this search vis-a-vis another person doing the draw, the person that gets in the way doesn't have a lawful authority necessarily to be able to say, no, I'm not going to apply. And so where we apply this, and State v. Stone makes pretty clear, is whether or not you do have this lawful ability to say no, right? So in Stone, officer pulls over a car and the occupants are kind of playing a ring around the rosy, so to speak, with the car. And then none of them are really kind of complying with the officer's orders to stop and to answer some questions. And so in that case, the individuals were charged with impeding, and the Supreme Court said, no, this isn't impeding. You have a lawful right to walk around the car if you want to, for example. If they had been placed under arrest, that would have been a different story. And so by actually making it a crime to hinder, you're saying, no, you don't have the lawful authority to impede the draw of this blood. And as was discussed earlier, we really feel this is appropriate because, first off, it gets to the nature of the offense. Someone's being charged with committing DUI. There may be all kinds of other reasons why they didn't want to give their blood, but that's an argument that they can make to the court or to a jury, just as they would in a typical criminal refusal case. I personally don't believe that this is fair to be charging people with 3-year or 5-year felonies. I don't think that's what's intended. It doesn't really address the underlying behavior. My recollection on this issue is it mostly affects, young men. Most of our DUI offenders are men, and then you have young men who may be particularly disinterested in assisting in their own prosecution. And so they're, saying no way without really fully comprehending all of the consequences. So this actually provides a warning that has to be given to them and implied consent so that they know that this is a violation of law because they might not otherwise be aware of that fact. And on top of it, it treats it as a DUI instead of a felony where they're not going to be treated by DOC as a DUI.
Did you have any issue with whether, the question I raised on page 9, that whether or not a search warrant is sought? I
I agree with Attorney Paul's analysis on that. And I too find it frustrating when the legislature has historically covered two questions in one subsection, instead of having them separated out, but, I was trained in New York, so. Thank
So
you.
in the future, don't be as confusing as this, but because this has been in practice for a long time,
Yeah, I don't,
know how to work it.
yeah,
Okay, all right.
thank you.
That's all you had as far as anything else?
Yeah, I mean, as far as the task force is concerned, I can assure you that, as long as they're federal grants, paying my salary, it would cover this, membership in this task force.
If there's not.
Then I'll be, I don't know what I'll be doing. Maybe I'll be DJing or something. I don't know.
We'll be on the task force. right?
Bigger problems.
All right, fair enough. Judge Zone, if you could start. Actually, I think this is the first time we've heard from Judge Zone, so the whole bill is obviously open for your input on it.
Good afternoon, Tom Zone, Chief Superior Judge. Certainly, certain aspects of the bill are a policy. I will comment on some of your questions. Yes, I agree with what Phil was talking about for 5229. I think that the language surrounding adjudication does work. As Marshall said, it's an issue that we all in the courts understand, and I think that will work. I do agree also that the language about a warrant being sought with that comma in that sentence, that's fine too. We understand what that means, and that's not a problem. The bill seeks to also, when I first read it and it had the refusal in there, I learned about the hinder. I didn't know about the 1.1 version until this afternoon. And so I must acknowledge that my first question is why change the word to hinder as I was sitting over there. And then I thought it was exemplified as to the potential difficulty of that when Representative Goodnow says, does saying no hinder? If you have an attorney has to ask that question, I think that lets you know that there might be some questions coming up down the road. And let's play this out for how it really works. In a situation where someone goes to get an officer applies for a search warrant and they go to the hospital to execute the blood search warrant. The defendant looks up and says, no, I don't want you to have that blood. Does this happen?
Me.
But you're. Sometimes, right? But then
I'm sure it happens.
that would be the circumstance. The defendant says, no, I don't want you to draw the blood. Is that hindering? Does it have the direct impact is it any different than if you're standing at the front door of your house and the police show up with a search warrant and say, we're coming in with our warrant, and the person standing there goes, no, I don't want you coming in. You can't come into my house. Are you going to go in anyway?
Yep.
Now, the difficulty when you have warrants for blood is that you have doctors or medical professionals who would have to do the draw. And then the question is, do they allow the draw to take place? If a defendant, an individual who is in their care says no, my understanding was that most medical professionals will not draw that. And so I think by using the word hinder, and I agree with Mr. Wigmans that the Supreme Court has defined it as having that immediate effect or making more difficult what law enforcement is trying to accomplish. I think by using that, you do build in some questions. And I guess my question is, if you're saying that by hindering, we're treating it as a refusal, why don't you just say it's a refusal? If you refuse to consent to law enforcement obtaining a search warrant for executing a search warrant for blood, that is the offense that the legislature determines is appropriate.
So maybe this is a question, well, for Ben and for whoever. So we don't have a refusal anywhere. We're suggesting refusal is encompassed in hinder. I just want to clarify, make sure I understand that. So why can't we say refuse or hinder?
I would note that currently you have a refusal for someone taking a breath test. And the legislature has enacted statutes that say if someone refuses to submit, there are times that law enforcement will say, well, we are treating this as a refusal because of your behavior. And the Supreme Court has addressed that. And law enforcement would say, look, you're not letting me get this test. And so we have not had, as far as I'm aware, a push to say, well, we need to add hinder there. The word refusal has been interpreted by the Supreme Court. There are many cases there. It seems to be known in the field as to what a refusal is, that I I don't know that you need to start carving out a separate category of what a refusal is. If you want to make it clear and say, well, if you refuse or, given the medical issues, you shall not refuse a cert to allow a search warrant for a blood test or consent, something like that. I think that seems to go in the direction that you're looking for. But again, hinder, I can envision a case where someone comes in and goes, I didn't hinder, I just said no. And that's my constitutional right, that I don't want somebody entering a needle in my arm.
So it would be, your suggestion would be a person suspected of violating this section shall not refuse to submit to collection of an evidentiary blood sample, something, I mean, that.
Well, to submit to what you're really seeking here under this new statute is submit to a blood draw, by search warrant, right? That's the essence of it.
Okay, all right.
And in doing that, I just want to make it clear for the members of the committee that right now, if you look at the statutory framework, refusal to submit to a test, whether it's a blood test or a breath test, is something that can be used against the defendant introduced at a trial. What the legislature has said are there are certain circumstances, though, where if you refuse, if you have a prior conviction and you refuse, that's a crime. We think the circumstances are different there. Or if there's a serious bodily injury, we think it's different that if you refuse, there's a crime. And you should be aware that the impact of this statute does reach to a DWI-1. For instance, if someone is suspected of DWI for being under the influence of drugs and a police officer seeks a warrant to obtain that blood test from them, and they refuse and do not allow that warrant, they haven't just committed a DWI. They've committed DWI plus this additional charge that the legislature is adding. If you are a DWI-1 and you refuse, you have your with alcohol, you just have a DWI. So you should be aware that you are creating a different category of individuals who are subject to two charges for a DWI-1, where someone else would be subject to a single charge. That's a policy decision.
Well, it's a policy decision that we need to make sure that we're conscious of making, and I don't know that we really understood that part. So,
Because if you look at, and I apologize, I don't have a paper version, but I have it on my phone. If you look at on page of 1.1, up there, I apologize. If you look on page 3, line 9, this is where you start talking about the refusal. And this is where the language used to be for this search warrant issue. A person who has previously been convicted of a violation of this section. So you're saying if you've previously been convicted of a violation of this and refuse a law enforcement's reasonable request. So it's a refusal plus the previous conviction. If you drop down to C on line 19, a person shall not operate or be involved in a crash or collision resulting in serious bodily injury and refuse. And so you've said it that there's certain criteria. It's not just a refusal that the legislature has previously indicated justifies an additional crime, but it's something else. And I just wanted to point out to make sure everyone was aware that if this goes forward the way you have it currently, you are reaching back to, again, the DWI-1s with individuals for drugs, which we do see quite commonly.
so J is not tied to B and C.
That's correct.
It's a whole separate. You following that, Ben? And
Yes.
So, okay, this wasn't very clear to me.
You don't have the introductory clause from B1, from B and C. And I just noticed, if you do go on 1.1, Ben, you don't need the one after B if you've already taken out 2.
It's true. But also hasn't been edited.
Well, So I would like to have, I guess, the other witnesses' input on whether we should have those precursors in J as well, and why we're not having those precursors, you know, the being previously convicted or being in the crash. Is that question, Ian?
Yeah, that was, I think, especially if we're trying to line it up with sort of the refusal on the evidentiary breath test, which was the gap right now, right?
And a possibility is just to add language to what has now been struck as two, but maybe create another two to join that with J.
Right. So, yes, okay. So the question is whether we want to be a whole two charges instead of one, right? Essentially, is what correct.
And this could be for alcohol too, correct? If it was,
Well, you can only request a blood test if a breath testing equipment is not readily available.
so they're at the hospital or,
Then breath testing equipment is not readily available, and then you fall under subsection, then you fall under the blood testing regulations.
yeah, okay, so this could be a same thing where you could get two charges on a DUI one with alcohol as well.
Right.
Within it, yeah,
If there's not the blood breath testing
being
available.
available, yeah.
Okay, all right. Yes.
That's it for that. As far as the task force, that's up to certainly the legislature if you to study that and take no position on that.
Okay, all right, thank you. Okay, let's hear back from Marshall again on this issue we just talked about, and then we'll give Dennis and yeah.
So we definitely considered the fact that this could lead to two charges and a DUI one. From our perspective, we didn't see that as a problem because currently, under the same scenario that Judge Zoney described, you could still see two charges and a DUI one, but the charges you would see would be the DUI and impeding, which is a more serious charge than refusal. So from our perspective, if we're going to be addressing, both the refusal and the DUI, it's better to address the refusal through the refusal statute than through the impeding statute. So that was the reason why we didn't raise that as an issue. That said, it certainly could be stated in there that, with criminal refusal for refusing to submit to a blood draw pursuant to a warrant is only criminal refusal if the person has been previously convicted under that subsection. You could do that just like you have for other refusals. My concern would be, would we then have prosecutors prosecuting impeding rather than refusal? And that's, a much more serious offense. And it's also just sort of less relevant. It's less tied to, like, DUI has a really specific sort of body of law and a very specific sort of set of kind of treatment obligations and everything that goes along with it. And from my perspective, it's better to treat refusal as refusal and not treat it as impeding.
And are you okay with going back to the language of refuse to submit to as opposed to hinder?
Yeah, I think the reason we came up with hinder was because I had brought up the objection that the original language said refuse to comply with a search warrant. And my objection to that is that search warrants actually don't direct individuals to comply with anything. They're directions to law enforcement. And so if you search in Westlaw for fail to comply with a search warrant, you find lots of cases about law enforcement failing to comply with a search warrant. You don't find cases about individuals failing to comply with a search warrant because they can't. So I had just objected to that language on that basis.
We don't have that language anymore.
Right, we don't, but we replaced it with hinder, which, as Judge Zoney said, does open, that's sort of expansive. And I don't object to Judge Zoney's proposal to change it to refuses to submit to a blood draw pursuant to a warrant.
That's what it would say now, refuse to submit to collection of an evidentiary blood sample.
Right.
When a warrant, yeah, so.
So
It's that common.
to me, I agree with Judge Zoney that would accomplish essentially the same goal in probably a more clear manner. So that we wouldn't have questions like, what happens if someone just says no? Is that hindering? I think that would address that.
Okay, right. Appreciate that. Question? Yeah, Ian.
So can you get charged with criminal impeding if you refuse a DMT?
It's a good question. I've never seen anybody charged with it.
And so for DUI one, why, if they can, why aren't officers charging them with impeding? Because they don't have an ability to charge them with something for refusal when they don't take the DMT.
Because DUI one, you have a right not to flow into the DMT if you want.
Couldn't you apply that same logic to a DUI one with a blood test?
I don't think so, because when a judge issues a warrant, then
That's the
the judge has issued a warrant. There's no, it's not offering an option like they do in the sort of statutory scheme. It's
Yeah.
now you're into the world of a judge has issued a warrant,
Yeah.
and if you interfere with the execution of a warrant, you typically charge with impeding.
Yeah,
Um,
thank you.
All right, thank you. We'll have Dennis back to weigh in on those couple things that we have.
See, there's still a seat here. Let's talk about childhood games running around circles. I'm thinking about the Duck Duck Goose. So Dennis Wigman's again, state's attorneys and sheriffs. The language of refusal was one that I initially had proposed because it is consistent throughout the statute and has a well understood meaning. We certainly, support going back to that language. With regard to charging more than one, we can charge more than one right now. We can charge somebody with under the influence and a 0.08 violation, for example. It really comes down to what you can get sentenced for. And because it's the same transaction of facts, well, actually, this might be a different transaction of facts because you're talking about circumstances where somebody's refusing, but you can still implement, and there is elsewhere within our statutes, a limitation and say that that a person that commits an offense as covered under 1201 A, C, and J, for example, can only be convicted of one or the other. Because right now, as it stands, there's a conventional law that says you can't be convicted of a committing basically the same transaction of facts unless the legislature steps in and defines those circumstances where you might have the same transition of facts, but you have two different violations. Does that make sense? And so really what we're talking about here is it can be limited in statute. You can say, and I don't think we would propose anything to the contrary, you can say you can only be convicted of one of these, not all. Does that make sense?
It does.
So in 1210, I mean, I can send over some language for suggestion, but under 1210, so the way that our DUI statutes operate is under 1201, you have the charges, right? You have what is a criminal violation. It's not penalized in 1201, okay? It's penalized in 1210, except for that one little carve out for the circumstances where a person is injured or killed, and then you're refusing. And if you look at that language, what's interesting is that it actually says that you can be charged with refusal, but only after the court issues a warrant and an order that you comply with that. Okay, so you're going back to the judge twice. You're saying, okay, we got a warrant, judge, and now the person's not complying, and we'd like an order for them to comply. I don't know how much of a difference that's going to make in most circumstances. I don't think that people are going to go, oh, now it's an order for me to comply, I better do it, because they don't really comprehend the distinction. I don't think that most people comprehend that distinction. They see a warrant and they're like, I'm not doing it, or I am.
Right, to simplify this, because maybe it's the late afternoon.
Sure.
And sounded a little bit like the Peanuts adults to me for just a moment.
I get you.
And I apologize, but I'm very,
Brevity is not my strength.
be very transparent. So I want to Marshall says, I'm fine with two. Judges pointed it out, it's not saying anything, it's our policy decision. Where do you fall on this?
I think that we would possibly see some prosecutors trying to prosecute and convict someone on both, saying that there's a distinction. I don't mind a clarity.
On which both would they be?
Under the Well, actually, if you treat it just as a refusal, I don't think you get there.
So, no, but which would the both be? Just,
So the both would be if you had hindering and a DUI. If you treat it as a straight refusal, I'm not sure that people will be able to make that distinction and argue that they could be convicted under both circumstances.
so you're good with where it is right now? And you're not
I
concerned
proposed
terribly about
it.
the two?
Yeah. I'm good with it. Yes, thank you. I don't, I mean, I'm also mindful of overly complicating something that's already super complicated.
Yes, I
One of the
agree with
big
that.
struggles when I came here, when I moved back to Vermont from New York, was wading through our DUI law. It's really, dense.
Yeah.
There's a lot of there.
Yeah.
And so, I am mindful of like overcomplicating it. I'm offering as an option that you could say a person can't be convicted for more than one of these offenses under 1210 or, punished for more than one of these offenses in 1201 under 1210. That would work too. And I'm happy to draft a one-liner that would address that issue if the committee sees it as a problem.
Marshall, do you like that approach of having some additional language that
I'd like
is
to
that
look at it.
overly complicated?
I'd like to commit.
Of course, yes,
Yeah.
of course, I understand that part, but is this worth pursuing?
Sure.
Are we good
Yeah.
with pursuing that?
I think that's a really elegant way of sort of.
Well, if Ian thinks it's elegant, I disagree with you.
And to get to the point of whether or not DUI one offenders are charged, I mean, that's kind of the whole purpose of this, is to ensure that somebody who's committing a misdemeanor isn't now suddenly facing a felony unwittingly. And so that they would just be treated as a DUI offender.
Right, so if you could, go ahead, Ian.
Well, I think that, so, yeah, I think I really misunderstood that the way that this would be charged would be basically a DUI refusal, but
Yes.
for the, like, not complying. So, yeah, I thought it was going to be like another charge where, like, let's say you got into an accident. So it's like gross negligent operation, DUI, and refusal of right? So, but the way you've seen it, and I think the way that everyone's interpreting it except me, is that it's just going to be a DUI refusal, and then if you had also DUI, like over the legal limit, right now you charge them both, but you can't actually be convicted of both, so they're going to pull one or the other
I
depending
think
on.
the judge might want to comment on this, but
Marshall, closer.
Yeah.
I'll let Marshall go.
I was just gonna say, I think you can be convicted of both. I mean, I certainly see that happen regularly.
of both 08 and under the influence.
No,
That's what I mean.
So impeding and DUI.
oh, right. I don't think you could get, I think you could get convicted of 08 and under the influence, but you couldn't get sentenced for both. You'd have to have like one sentence.
Yeah. And that would do the same thing here effectively. Yeah.
See what the language looks like, but yes.
We're
theoretically.
very close, but we're gonna have, if you could work with Ben on that one bit, and we're gonna have new language that Marshall had suggested. If you need to get that from Marshall, I assume that you have that, but you can certainly get that for the 5229. Is that the section? Anything else you need, Ben, for the next step? You're good?
Yeah.
Yeah, for now. All right, so I guess we'll be back to this again. Let me see, is it possible that we can look at this again tomorrow afternoon?
Afternoon, I'll have to look at my calendar.
I have H44 scheduled for 2:00, but it's scheduled for committee discussion, possible vote. I don't think we're gonna be quite ready for that, but we can go over kind of this final language, hopefully.
I can do it online.
Yeah, that's great. No, that's.
Wife is out of town and I'm
No, that's
the driver then.
We absolutely are fine with people.
I'm the driver most of the time.
I'm being on Zoom. That's absolutely fine. So, yeah. So if we could take, we'll take just a 5-minute break, and then we're gonna look at the